Hello, I'm Henry Quillian. We're here at Quillian's Kernels at Taylor English Numa. As we all know, this is a tutorial class where we talk about how you go about litigating in federal court. The focus of this session will be the very preliminary stages of a lawsuit after it's been properly commenced, also known as the Rule 26F conference, which leads to the Rule 16B planning conference and order. For those out there in the world, you should know that we are not providing legal advice. We're providing guidance as to how you, or preferably your attorney, might go about doing litigation. We're not intended to be giving you any legal advice, and you need to read the rules yourself. In fact, what we talk about in every Quillian's Kernels is that we have to read the rules for the particular jurisdiction in which we are litigating, and really you ought to know everything you can about those before you ever commence the litigation. So the focus of this session is really the pretty fast and somewhat complicated commencement procedure that you have to go through once you get stuck in a federal lawsuit. Unlike in Georgia state courts, unless the court calls you in for a scheduling conference, there are a lot of things that have to happen pretty early on in federal litigation, and that stuff is complicated by the fact we've got the federal rules, and then we have local rules that change around timing, change around requirements, and also set forth a pattern of timing that is very complicated. A lot of times you have an outside deadline, and then you have to count back from that deadline in order to find out when you have to do something, or you have a preliminary start point, and then you have to count from there, but then you have to check to see whether that date is actually later than the date that you're counting back from for another deadline. So it gets really, really confusing, and of course just to keep us all employed, they change those timing and rules every so often so that we will stay in business. And the ultimate goal of what we're going to discuss today is that you will have thought about your lawsuit fairly intensively very early on in the lawsuit, thought about all the things you need to prove, thought about all the evidence you need to get, thought about how you're not going to get in trouble by not preserving your electronically stored information, thought about how long it's going to take you to do this and whether you have the people power aboard to get it accomplished. If you don't have that amount of power, then you're going to have to get more time to accomplish what you got to do, so that you don't end up tripping all over yourself or having to constantly try to come up with reasons why you haven't completed what you were supposed to complete, or you haven't gotten this evidence, or you need to take another deposition and you don't have enough depositions, etc. So what happens is, of course, what we've discussed so far is the plaintiff brings a lawsuit, it gets served, the defendant files a motion to dismiss or not, but one way or another we've gotten to the point where the defendant has to participate in the litigation because they didn't get the case dismissed, and so they have to file an answer. Or they may have filed a motion to dismiss and they still have to go through this procedure anyway, which is called the Rule 26F planning conference. Now, what we're of course talking about is the Federal Rules of Civil Procedure, Rule 26F, which is 26 is the major discovery provision of the Federal Rules of Civil Procedure. And it's sort of weird because you read through all this stuff that you're going to have to do after the 26F conference before you ever get to F, which is supposed to be before. All you have to do before, you have to do all the things that are before F in Rule 26. So it's one of those things where, you have to read everything before you know anything. It's like reading a contract, and after pages and pages of contracts, it says at the very end, notwithstanding anything foregoing herein, none of that applies. But so Rule 26F requires the parties to basically get together and to plan their entire, what they foresee will be the entirety of the case. And that's pretty darn difficult because it has to be done within a limited period of time. Now, in the Northern District of Georgia, as we discussed, there are always local rules for any district court, any federal district court. And the Northern District of Georgia, of course, has its own set of rules. And those rules, if you were just to read Rule 26, you would be all jumbled up because it gives deadlines that are different and frankly more liberal than the local rules. And the local rule, even though you're talking about a Rule 26F conference, is local rule 16.1 and 16.2. So here you are, you've got local rules that aren't numbered the same as the federal rule. The local rules drive when the federal rule conference has to take place. So what do you do when you're in doubt? You read the rules. If you get into federal litigation, maybe you ought to read all the rules before you even start doing anything. But as we know, we all take things step by step. So, what has to happen? Well, when the answer or motion to dismiss has been filed, a conference has to happen that shall be held, this is local rule 16.1, within 16 days after the appearance of a defendant by answer or motion, and shall comply with all the requirements of Federal Rule of Civil Procedure 26F. Now, what does that mean the defendant has to have been doing from the moment they got served with the complaint? What would be a one-word summary of what a defendant has to do right after getting the complaint?
Preservation.
Excuse me?
Preservation.
Well, they have to preserve, but that's a technical thing. What would be a colloquial term for what a defendant has to do as soon as they get served with complaint, assuming they don't know anything about it to start with?
Worry.
Worry is one. That's a good one. That's always good for lawyers to worry. If you ever fill out a disability policy and say that you've never had anxiety as a litigator, you're lying and they will disavow your policy if you ever have a disability. So I was going to look for the word scramble. The defendant needs to start figuring out a lot of stuff really fast. Why? Because how many days do they have to answer once they get served if they're going to answer? 21. And then within 16 days after that, they have to have this conference. And you will be surprised how many things the conference covers and what the defendant is supposed to have figured out, and theoretically the plaintiff may have had a luxury of time figuring out some of this stuff before filing the lawsuit. So, how many days after the appearance of the defendant do you have to hold the 26F conference?
16 days.
16. And it says, counsel are required to inform the parties promptly of all. One of the things you have to discuss is settlement on top of everything else. And so, you've also got to not only figure out how you're going to litigate it, you also got to figure out how you might settle it within that limited period of time. But some important rules, words are in this rule. Prior to filing the joint preliminary report and discovery plan, which is the end result of all this effort, was the preliminary to the scheduling order. Lead counsel for all the parties are required to confer in person in an effort to settle the case, discuss discovery, limit issues, and discuss other matters also addressed in the joint preliminary report and discovery plan. Now, so those out there in the world don't think this is a lot of work. This is a sample joint preliminary report and scheduling plan. And so it's got a lot of pages, got a lot of check boxes, got a lot of decisions to be made. And so therefore you have to scramble to start thinking about all this stuff. And then you also got to talk to your clients. Hey, can we get this settled, Julian?
How many Did you say that you have to do that while a motion to dismiss is pending?
Yes.
Yes. So.
But
it's
you
the first-
can, I do this all the time. I file a joint motion to push back all the deadlines pending a ruling on the motion to dismiss. And I haven't had a court yet turn me down on that, but I guess there's always, always a possibility.
Okay, so what Mickey is proposing is it's required unless you can get relief from that requirement.
Correct.
And you'd have to do that by court order.
Yes.
Right?
Yes.
Because,
Once the judge rules on the motion to dismiss, does the movant have an opportunity to appeal before the litigation commences?
Not really. No.
when you say, you mean if they deny a motion to dismiss? Yeah, if you deny a motion. Excuse me?
I was gonna, I know there is a federal interlocutory appeal statute, but I think it's pretty tough to get that.
Okay.
Nearly
So-
I don't think I've ever done it.
But if you have a motion to dismiss denied, yeah, things are gonna start moving forward. And you can try, I suppose, to make another effort to get rid of the case somehow or to get it appealed, and I don't know, and I haven't read that yet. We'll talk about that towards the end of this course. Okay, so the other thing that it mentions here is if the filing deadline for the certificate of interested persons has not already passed, council may wish to include a certificate of council's agenda and include that certificate on the council's agenda for the meeting. In other words, the parties need to know who all the parties are and who all the affected parties are that may be involved in this litigation so that they can sort things out earlier on that would be bad if they don't find out until later on. I believe certainly the plaintiff's certificate of interested persons will have already been due by that time, and likely the defendants would have also, unless you have this conference really fast after the defendant appears. Okay, now there is one nice thing, which is the court rules provide a form that you can use, that you must use in order to do this joint preliminary planning report. But of course, the form just has lots of blanks in it, and then so you have to figure out what those blanks, how they're going to be filled out, and some of them would be filled out by paragraphs, etc. Now, basically, what the plaintiff has to, what both parties have to do is they have to describe briefly the nature of the action. And the way this often works is, probably should work, is one party, likely the plaintiff, before having this meeting with the other side, it makes a lot of sense for there to be a pro forma preparation of this plan proposed by the plaintiff to the defendant. So then you can decide what you already agree on and cut down the issues at the conference. And so there's a whole lot of things that have to be covered, and there's a certain number of those things that are going to be in dispute between the parties, because just in general, you're laying out your plan for the duration of the litigation, which includes such things as whether or not you're going to have a short discovery period or a long one. You can't necessarily decide that, but you can influence that. You can decide or make a proposal to changes to the federal rules on the number of depositions and interrogatories that you might be able to serve as part of your discovery plan. And you can, as Rachel Zakella will cover shortly, you can dramatically affect how things will be handled with respect to electronic discovery and other discovery issues as part of this. So if the plaintiff prepares a preliminary report that's not joint yet, then it can be sent over prior to the conference, and that provide a basis for a discussion between the parties. Now, what's the risk of going ahead and preparing your side of the report? You're telegraphing, you might get something from the other side that's even better than you would have proposed, right? depending on what you're wanting. If you, let's do something really simple. You say you want 30 interrogatories instead of, as marked in here. Rule 33 limits you to Federal Rule of Civil Procedure, Rule 33A1, limits you to 25 interrogatories, which, depending on the case, isn't that many. Some courts, I understand, even limit it dramatically lower than that. But let's say you think you need 40, but you think the other side's going to push back on that, so you offer 35. In your preliminary report, you find out after the fact they may have gone to 40 anyway, or they might have proposed 40 when you showed up at the meeting. So sometimes you could just leave blanks in there to make sure you cover the subject matter and not put anything in, but put your arguments as to why you need more, at least. Let's just sort of go through this form and just look at the subject matter, so those out there in the world, and so y'all will know. So it's briefly describe the nature of the action, summarize the facts of the case. The summary should not be argumentative nor recite evidence. That takes the lawyering out of lawyering. The legal issues to be tried. Now that's a lot to figure out if you're just taking on a lawsuit. And of course, you don't know what the other side will agree to, but you can put down what you think you're going to have to prove if you're the plaintiff. The cases listed below in both style and action number are pending related cases. So if there's another case that's already pending that's related to the case, and then previously adjudicated related cases. And then you have an argument you can make by filling in a checkbox. This case is complex because it possesses one or more of the features listed below. Complexity can drive what the discovery schedule would be, or it could drive the number of depositions or the number of other discovery tools you can use. So let's just look at the list real quickly. Unusually large number of parties, unusually large number of claims or defenses, factual issues are exceptionally complex, greater than normal volume of evidence, extended discovery period is needed, problems locating or preserving evidence, pending parallel investigations or actions by the government, multiple use of experts, the need for discovery outside the United States borders or boundaries, existence of highly technical issues and proof, unusually complex discovery of electronically stored information. And then there's a listing of counsel. You have to list the lead counsel for both sides, specifically designating them. So then you also have things you got to work out within your law firm, in addition to all these other things before you can do this. You question whether the court has jurisdiction or not. There's a yes/no box. And of course, if there's a yes marked, if you think the court is lacking jurisdiction or there's a question, you would need to put down what the objection is. You have to list anybody that needs to be a party to the action who isn't, a necessary party, a party that's been improperly joined, somebody that shouldn't be in the litigation, and also incorrect naming of a party, misspelled names, etc. Okay. Then you have to get to issues relating to what you might anticipate relating to amendment of pleadings. For instance, you think that if you can just get this fact, and this fact, such that you have enough evidence to survive a Rule 11 problem, that you might actually have an additional claim or an additional defense. And however, the general premise of this from the court's point of view is, let's keep the litigation as narrow as we can, let's keep the litigation as regimented as we can, let's move the litigation as long as fast as we can. So basically you need to give a heads up to the court and these issues relating to possible amendment of pleadings that you need to take into account. And there's actually the part of the form in here, it says amendments to the pleading submitted no later than 30 days after the joint preliminary report and discovery plan is filed or should have been filed will not be accepted for filing unless otherwise permitted by law. So that's part of the form, the local rules form. So that gives you a heads up. You got to get your act in gear with respect to getting your pleadings together, unless you think you're going to have a really good reason down the road that if you find new evidence, you're going to be able to persuade the court to allow amendment of your pleadings. Yes.
Because I dealt with this in a case, I think there's some inconsistent language in the local rules of the form regarding whether you have a right to amend within 30 days after filing the report, or whether you still have to move under Rule 15 for leave to amend. We had a case where we amended within 30 days after the report was filed. They came back and said, no, there's additional language there that says you still have to comply with Rule 15, so you had to file a motion for leave to amend. So I don't know what the answer is. Just be wary if you assume you have the automatic right to amend within 30 days of filing the report. That may not necessarily be the case.
Okay, and having gone through the previous, having done the Quillian's kernels, it would look like this language just says this is an outer limit problem, but that Rule 15 may still apply and put the limits on when you can move, when you have to move to amend. So that makes sense. The other side may have been correct on that. But were you successful anyway in amending your pleading?
Well, we said we filed it timely, and then we moved to amend anyway, and the court granted our...
Yeah, I knew it would. He wouldn't have brought it up if the court hadn't agreed to amend the pleading. But yeah, sometimes there's it's like, you know, just outer boundaries on what you can do, but there's another rule that has more requirements on you. Because this does not say you can do it. It just says you can't do it after this time. Okay, and then I won't go through them all, but basically there's limits on when you can file various types of motions, like motions to compel, motions for summary judgment, motions objecting to expert testimony. And then one of the major things, which we're not going to cover today, but it's all that first part of Rule 26 relating to initial disclosures, that part that you read before you can even find out you can even do it. There's something called initial disclosures under the federal rules that forces litigants to go ahead and cough up a lot of information regarding their case and regarding what they anticipate from the other side. And you can discuss and negotiate with your opposing counsel regarding when those initial disclosures will be done, and also whether there's any special objections your client has to producing that which was in the initial disclosures. Because sometimes the initial disclosures could force your client to produce things that you think you would have a reason why they shouldn't have to produce, and you have to put those objections in your preliminary report. You can decide whether you want to have a scheduling conference, whether you want to ask for, for a scheduling conference with the judge. How many people have asked for a scheduling conference with a federal judge in the Northern District of Georgia in a, let's call it, for the moment, a run-of-the-mill litigation where there's no huge dispute between the parties and have gotten one?
Before filing the plan?
Well, after filing the plan and putting in there with the other side, we would like to have a conference. I don't know if the judges are prone to give that or not. Usually the parties don't ask for one, so you never find out. How many people have had after the filing of the joint preliminary plan, but before the issuance of the scheduling order by the judge, have you had a conference? Not very many. It doesn't seem to happen very much. See, I would think if I was a judge, I would want to see the parties as soon as I could. So maybe you could ask for one and see what happens. Even if you don't have a whole lot to talk about or a whole lot of disputes to work out.
Well, in other jurisdictions, sometimes they require you to appear. They require both parties to appear after you've submitted the order, and then the judge asks you questions about it, and then the judge will enter an order. And sometimes they'll enter the order that the parties have submitted, and sometimes they'll amend it themselves and change it. But that's not the practice here in the Northern District of Georgia. Just happens in other jurisdictions.
Ultimately, the judge can change things up any way the judge wants to change things up. But hopefully, there would be with some cognizance as to why the parties believe it should be different from what the judge has in mind, so the judge doesn't get the parties and the court itself into sort of a mess. Okay, you can discuss how long the discovery period is, which essentially is, what's the standard discovery period in Northern District of Georgia?
4 months.
4 months. But all those issues that I talked about, those checkbox issues earlier, that type of thing can influence whether you can get a longer discovery period. And then also, if you have certain types of cases, you're automatically entitled to a longer discovery period unless the court makes a different decision. And that would be things like patent cases. Is antitrust?
Antitrust, 8 months.
Antitrust. Cases that sort of inherently are very complex and need more fact-finding time, etc. And you can, you actually have to lay out what you anticipate your discovery is going to be on the case. And of course, if it's a whole bunch of things, you need to start thinking about ways of trying to get more time to achieve that discovery. When does discovery start in the Northern District?
First answer.
30 days after the answer.
It's 30 days after the
After the
answer,
answer.
and it has to, I was actually looking at that. It appears that you have to have a conference before you can start discovery, and so that would be a reason to accelerate the timing of your conference if you really wanted to get your discovery going. And of course, there's exceptions to that, but I'd have to find the exact wording. But basically, you're not supposed to do discovery until you've already had this Rule 26F conference that we're talking about. So if you're wanting to delay discovery, what could you theoretically do? At least for a minimal period of time.
Put off the conference.
Put off the conference, but then again, there's a limit as to when you have to have the conference. So you work through these things with the other side, and I can give you an example of things where we just knew in advance there's only a 10 depositions of right you can take under Federal Civil Procedure 30. And that's, in any sort of case of significant complexity, that's not very many depositions. So if you already know that you've got, because of your preliminary investigation, that you've got 20 people that are far-flung around the United States, that the only way you can get discovery from or get testimony for trial is by deposition. Should you go for or propose putting a larger number of depositions in the preliminary planning report? Yeah. So a lot of forethought can be put into this so you won't have to come back begging for the court in order to do everything you want to do. Now, the court may not agree or the other side may not agree. Each side has to put up their position and then the court decides what they're going to do. Here's one that's of importance. You can decide whether you want your case tried by a magistrate judge. And my general understanding is that is a not very often used option by litigants. But what I do know is the magistrate judges in the Northern District, at least they've expressed to me that they would really like to have cases that they can try. And because they would really like to be doing full-blown trials. What factors would you utilize in trying to decide whether to have your case presented ultimately to a magistrate judge rather than an Article III judge?
Well, we recently, I think the employment group went to a talk before a magistrate judge, and as a ploy for us to consent to magistrates, he said that you can have a set date for your trial. Instead of being put on the trial calendar, the magistrate judge could actually take out their calendar and give you a definite date for when your trial is going to take place.
And did they give any indication of whether they thought that date might be sooner than a Article 3?
Definitely sooner.
Okay.
Definitely sooner.
So that would be an issue, I would think, if you've got to get justice quickly, then an Article 3 judge, they get all caught up in these huge drug, trafficking trials and this, that, and the other, and sometimes have to put off civil cases for a very long period of time. So now, in Northern District, can you know who your magistrate will be before you consent to trial by magistrate?
Isn't it just the magistrate that's assigned with your judge? When you're filed?
Let me back up here. I'm not aware of a magistrate being assigned to a judge
No,
that
but
you can find out before you have to file this.
sometimes aren't you assigned your magistrate with your judge?
Yes.
Well,
That's what I thought. So they, yeah. They- And the
And the
magistrate
caption of the
judge,
case will have the initials of
yeah, it
both.
has the initials of the of the
And the
magistrate
magistrate.
judge. So when you're doing your plan, you can talk to opposing counsel about the particular magistrate and whether you,
But the fact that that's your assigned magistrate doesn't mean, I don't believe, that that's the magistrate who would try your case.
is that only in labor and employment cases?
Yeah, that's not.
I've never had a magistrate assigned a case
Yeah.
in Northern District in 24 years.
it happens, I guess maybe it only happens in
Right.
employment
Okay,
cases.
because the reason why I'm asking, employment cases are principally handled at all preliminary stages, I think. Tell me if I'm wrong, I don't do this work, by magistrate judges.
Right, and there's a two-tier summary judgment system in the Northern District, so the magistrate judge always reviews summary judgment before it goes to the district judge.
Now, in a lot of courts around the country, that's actually the way it's done for every kind of case. But in the Northern District, yes, Scott?
Yeah, no, we had a case in Texas where you get the magistrate, every case gets a magistrate, and the magistrate handles everything until you get to trial. And then even summary judgment motions get ruled on, and it's a report and recommendation, and then the district court either blesses or doesn't bless it. More often than not, it's a one-page affirmance of the magistrate court findings. But Northern District is not, if not in a Title VII type case, I don't think that happens.
All right, was that in a patent case?
Yes.
All right, so even in a patent case.
Yeah, I just had it happen in a trademark case in a different district in Texas too, and everything got moved over immediately.
Okay, that's certainly true in Pennsylvania and in Illinois and a lot of other places I've litigated. Yes, Paul?
Sometimes,
I think the 11th Circuit has ruled that the party's agreement to a specific magistrate to try the case is only an agreement to that magistrate, and if it gets switched later, the parties are not bound by whoever the court provides as just a generic magistrate. So you can shop for them a little bit on who your magistrate is. If you're assigned one and you agree to that one, that's all you agree to.
Okay, what if you agree to one in your joint preliminary planning report and pray that you can have that person?
Well, you should know ahead of time, or you shouldn't be agreeing. And most of the times, at least in the cases I've handled, is in the caption of the case, there'll be two sets of initials. The first will be the judge, and the second will be the magistrate.
So I guess the point there is, I think what we've sort of ferreted out is you'll know who your district court judge is, and we do have by the way, I think we've got very good quality magistrate judges in the Northern District, but you don't know whether the one that you get is going to have any familiarity with the subject matter of your case unless it's a labor employment case, I guess. And so it's somewhat risky to do that, but then again, sometimes if you don't like the judge you got, you may pray for any magistrate judge.
And Henry,
Judgepedia gives you great information about the background of some of the judges that are appointed, so it's a good source to find out whether they might have subject matter expertise depending on what firm they came from or where they came from. So it's a good resource.
That's Judgepedia.
Judgepedia.com. It's
How about
like
that?
Wikipedia, but Judgepedia.
Okay. I want to move along here so that Rachel will have time. A huge issue that we have to address affirmatively from the second we even learn about a litigation is the issue of preservation and ultimate production of electronic discovery and electronically stored information that can ultimately be discovery in a case. And we've had so many examples. We've done seminars here. Some of y'all were here, some of you weren't, about I'll call them "oh shoot" examples. I think we had it titled differently when we did the seminar. It wasn't videoed, and those "oh shoot" examples were ways that the firm, the client, everybody could get in very bad trouble by not doing things right. And then separately and apart from that, if you do it right, you can run a much more efficient litigation. So Rachel Zakella, who, as many of you know, has spent a lot of time working in this subject matter realm, and I call in on my cases to cover this area of practice when I'm in any court where I think I'm going to have significant electronically stored information issues, is going to handle this Quillian's kernels forward with respect to all the issues associated with this in the 26th conference. Thank you.
Hi. Thanks. Okay, so Henry did a great job of recapping the rules. Obviously, when you have the Rule 26F conference, one of the things that you're primarily supposed to discuss is electronically stored information. We're required to make disclosures in the joint preliminary report and discovery plan, and also in the initial disclosures about the volume of electronically stored information that the parties think is going to be relevant in the case. Because of that, I kind of want to direct everyone's attention to Local Rule 16.2. And in that section, the set of issues that Henry went over that counsel is supposed to discuss at the face-to-face conference includes, whether there's a greater than normal volume of evidence, problems locating or preserving evidence, an extended discovery period, the existence of highly technical issues and proof, and unusually complex discovery of electronically stored information. In almost every single case nowadays, we're dealing with massive volumes of email that needs to be culled. We're dealing with large servers. Sometimes companies have proprietary databases or other things that contain documents that you're going to have to figure out how to, retrieve, catalog, review, and then produce. And so it's just been my experience that almost no case is resolved within a 4-month discovery period if you have significant email or electronic discovery. So that 4-month track, I think eventually the courts are going to end up just extending that as a matter of course because parties are constantly seeking extensions of the discovery period. The way I look at electronic discovery is if you're the plaintiff, one of the very first conversations that you need to have with your client before you file the complaint is, okay, who is your IT person? And this is true if you're the defendant also, but when you're the defendant, you have a very quick response time, so it's different. When you're crafting your complaint, when you're looking at your issues, the very beginning, first thing you need to do is find out how the company, every single thing about how that company manages its documents, where all the documents are located, and every single thing about their IT systems. If it's a small company, if it's a big company, it doesn't matter. I always try to demand a meeting with the IT person. If you're dealing with an individual, the first thing, and it's just an individual, the very first thing you need to do is sit down with them and ask them about every single device that they have in their possession, every single device that they use, every flash drive that might be relevant. Do they have multiple phones? How many computers have they used over the last couple of years? Are they in the habit of using external storage devices? So it's really learning your client and getting to know how your client uses information, where they store information, and what their habits are. Do they use things like Dropbox or cloud storage accounts? So it's really just sort of taking an inventory of what the client's information systems are and how they save stuff. Because at the end of the day, when you're in discovery, your obligation as the attorney is to figure out where all of that information will be. A lot of times clients, you can ask the client, okay, did you give me everything? And then 2 months later, they're like, oh, but I forgot about this flash drive that I had over here. And maybe you never asked about it. Or I forgot about this cloud storage account. Or if it's a big company, oh yeah, we have all this extra space on our server and there's a whole bunch of documents out there. I mean, that's happened to me. And so I recommend always that being the very first thing that you do. It also might dictate to you when you're figuring, if you're the plaintiff, when you're thinking about the cost of litigation and what claims you want to make, the viability of your claims. Does your client really want to make X claim if it's a weak claim? If you think that claim is going to require you to then produce a massive number of documents. Is it going to pull in, if you're making a claim, for example, about a particular system that the client is using, is it going to pull in, are you going to be required to produce records that are stored in a manufacturing facility on some obscure database that measures the output of machines? Things like that. So if that claim isn't that great, one of the things you need to talk about with the client is the budget and what you're going to do, how that's going to impact the cost of the litigation. If you're the defendant, obviously, the very first thing you need to do when you get the complaint, you're drafting your answer, you're figuring all this stuff out, you're sending your litigation hold letter to the client. When you're sending the litigation hold letter, as part of or in tandem with your sending the litigation hold letter, you need to immediately be having conferences with the IT people at that company to figure out where all this stuff is stored. And so I think if it's a big company, you want to talk to the head of it, you want an in-person meeting. I recommend an in-person meeting and not a conference call. In-person meeting with the head of HR or whoever manages the people and the systems at that company, and the COO and IT or whoever your people are, to figure out where stuff is stored. And then managing that information, because you can't comply with your ethical obligation to answer all of these questions. And you will not know when you go into your conference with opposing counsel what you actually have and what the parameters are if you haven't already looked into that stuff. What's the volume of email? How many custodians? I mean, that's one of the things that's usually talked about at the initial conference is how many custodians, how many people do we think at this company are going to have email that's relevant to these claims? You need to know who those custodians are going into that conference. You need to have some kind of idea of how far back, you need to understand the company's email retention policy. Do they have a policy that just auto-deletes stuff after 30 days? Or has this company saved everything that goes back 12 years? All of those things are going to come up when you have your conference with opposing counsel. You want to talk about metadata. You want to talk about how you want the documents produced. If you're using a vendor.
What is metadata?
Metadata is basically the information, it's information about your information. So for every electronic document that's produced, for everything that you produce in Word, or for every email, an email is a good example. The metadata is the information that's contained in that particular email file. It contains the info about the sender, the recipient, the timestamp, just basic stuff like that. And one of the first things you're going to want to do is, in conjunction with talking to those IT people and figuring out where the documents are, is, okay, well, who's our vendor going to be for this stuff? And should we talk to our vendor and about costs, our vendor about collection, and then talk to our vendor about what the standard metadata fields are that we're going to request in discovery? A lot of times people will produce documents to you that don't have any metadata. Well, that becomes a problem actually on the back end when you're searching for documents later. If you haven't stipulated this stuff up front, when you're going back through and doing your review and you're searching, maybe you want your vendor to limit searches between 2 custodians for a particular time period. If they haven't produced the metadata, your vendor can't search those fields to cull that data for you appropriately. They have to then do word searches on OCR text in PDF documents or in native files, which might not get you every single thing that you want. So then your limits and the information that you're getting returned is not the best quality information that you could be looking at to review your documents. So it just kind of depends. the most important thing is just staying on top of the issues. It's asking the questions, it's learning about your client, it's learning about how the client stores information. One of the most important things is if there's been any kind of merger, or if you're dealing with a company that has acquired another company or been acquired, there's usually that's a sensitive area where you especially need to have those conferences at the outset, because a lot of times they'll be adding IT people from two companies that will come together, and there will be inconsistent policies in place. Or one person thinks that information is stored out here on the network, but the people from the new company don't know where the people from the old company dumped that information when they came together. It's just a question of being aware of everything that's out there so you're not surprised later in litigation. You never want opposing counsel to come back to you down the road in discovery and say, you know, when we had the 26F conference and we talked about documents and we asked you who the custodians were, you left out these 5 custodians because you didn't talk to the HR people or the operations people or whoever you needed to talk to, and you weren't making sure that that litigation hold included those 5 people. So that's really, I mean, I think it's just very practical, but most people wait. And it's been my experience that very few people will talk to the IT people. They always talk to a business contact about the issues, or they talk to the GC, or they talk to the, you know, whoever is hiring them. They don't involve the IT people early enough, and then later down the road in litigation, they're surprised by what they don't know and what they haven't found. So, you know, managing these things on the front end really starts with you and your learning about the client. And that makes you more valuable to the client also.
One of the things that's been pounded into my head, made me ashamed on occasion, is they say that in order to fulfill your ethical obligations, you have to be competent as a lawyer.
Mm-hmm.
And so since we're in this new realm, this understanding of ESI, electronically stored information, and e-discovery is actually one of the things that you're looked at to determine whether you're competent or not.
Mm-hmm.
And there are various ways to get competent. One is to learn it all, and the other thing is to engage people that already know the information you don't know.
Yeah, I mean, and this field is always evolving, so it's really hard to know. It's hard to practice law full time and then know every single thing that you're supposed to know in this area. I certainly do not know everything, and there's a lot of people that know way more than I do. But it's the more aware you are of what you don't know and the more you try to learn, the better off you are ethically in terms of just complying with your good faith requirements. Chances are, if you've educated yourself about this stuff on any level, you're probably no more than opposing counsel walking into that conference. If you are doing, you know, big scale patent litigation or something that's highly technical or trade secret litigation, and you're walking into a room with a big firm that has, you know, some guy somewhere that this is all he does, you especially need to know all this stuff walking in there, because you don't want to be agreeing to produce metadata fields that aren't necessary, or you don't want to be agreeing to produce documents in a some special searchable format that's, you know, 15 cents more a page expensive for your client than, you know, just producing native TIFF files. So it's really just meeting with your vendor, meeting with your client. That needs to be done as soon as you start assessing the validity of the claims. It also, you know, all this stuff is also relevant and valid to whatever the claims are that are asserted. If you have trade secret claims or confidential information claims or theft of those things you know, or if you're the defendant and your client stole the stuff, you need to obviously be talking to them about what they have. If you're the company and you're making that claim, you have the other side's going to try to challenge every single thing that your client does to maintain the privacy of that information or the confidentiality of that information. So it's also about talking to your client about how they store stuff. Are things password protected? You know, what are who has access to these computers? Who has access to this data? What other lawsuits are pending? You know, what other information are they putting out there, producing in other lawsuits? Are they making sure things are marked confidential when they're circulated internally? Are there restrictions? Is there a policy in their employee handbook about maintaining the confidentiality and preserving the confidentiality of company documents? All of that stuff in terms of the responsiveness of responding in your pleadings to the actual claim ties in with these electronic discovery obligations. So it makes sense to have a lot of those conversations on the front end. To that end, electronic discovery and production of documents is also an area where people frequently inadvertently produce documents that are privileged because they're not running a proper privilege screen, or there's just human error in the privilege screening process. So one of the things that you should talk about at the 26F conference, and there are actually opinions out there that say that it's malpractice not to have this conversation at the outset of that conference, is whether the parties want to have a Rule 502D order entered and ask the court to have that order entered. Rule 502 is in the Federal Rules of Evidence. 502D basically says it gives parties leeway on the production of work product, and it's designed to address inadvertent disclosures of documents. And Judge Peck, who's in the Southern District of New York, he's the magistrate judge who has written widely on the subject and has presided over some of the most important decisions in this evolving area, recommends a proposed Rule 502D order that's like three sentences long, and the parties, you can bring that proposed order to every conference, talk to opposing counsel about it. It helps everyone. And most judges will just enter that routinely. I've done it plenty of times here. You also want to talk to opposing counsel about a clawback order, and how you're going to manage clawing back documents and information that you may have inadvertently produced to one another, and how the parties are going to do that. It's much easier to get on the front end of those things, to deal with those things at the beginning before somebody makes a mistake, than to fight about it later when that mistake actually, people know what the implication of that mistake is as to their facts. So I'll just read this. It's the proposed Rule 502D order, the standard one. It just says, the production of privileged or work product protected documents, electronically stored ESI or information, whether inadvertent or otherwise, is not a waiver of the privilege or protection from discovery in this case or in any other federal or state proceeding. This order shall be interpreted to provide the maximum protection allowed by Federal Rule of Evidence 502D. So it's just simple, it's easy. You want to do that at every single conference. You want to be the person that brings that to the table. And even if you don't know what you're talking about, or you really aren't comfortable in this area, the other side's going to think that you know a lot more if you're addressing these things on the front end. So they're less likely to try to mess with you later during the process.
If the other side will not agree to a 502D order, can you get one anyway?
I would just propose it. You could probably file a motion with the court and ask the court to enter it. I've never had that situation because I think most people are aware that this could happen to them, and so everybody wants the protection. But I would just ask the court, or like you said before, if there are issues and you're having people are refusing to agree to things that are sort of basic and run of the mill, then you can just ask the court for a status conference and bring that up at the status conference. But anybody have any questions? Sorry.
Did you say Southern District of New York, Judge Peck?
Yep. I'll email around the 502D order, sample 502D order in one of his recent cases. Yeah.
Plug your CLE.
I beg your pardon? Oh, yeah. So a couple years ago, I worked on a matter with one of our colleagues, another attorney who used to be at Alston & Bird, who is now at KPMG in their forensics unit, and we got to talking about a lot of the variations and distinctions and the types of, there's just a disparity between what people know about this stuff, and you can see it in your cases. Some people are highly sophisticated on these subjects and some people don't know anything about it. And so we decided that the Georgia Bar really needed to have a section on e-discovery. And last year we petitioned the Board of Governors to start an e-discovery section of the Georgia Bar. And it was approved last January. We're having our inaugural CLE this month, October 30th, at the State Bar. We have several panels of speakers. Eric Fisher is going to speak for us on one of the panels. John Gross is going to be on our ethics panel. We have speakers from Sutherland. Lucretia Cade's going to be there from Morehouse College. There's going to be a lot of people talking about this. It's called the Nuts and Bolts of E-Discovery, and it's really aimed at just, the reason why we started this section was to increase dialogue about these issues between plaintiff's bar and defense bar, but also to just generally raise the overall bar of knowledge. In Georgia, we're kind of behind other jurisdictions. we're behind the jurisdictions that have rocket dockets and do a lot of patent litigation, or like the Southern District of New York that have a lot of complex cases. And so we need to kind of increase our level of knowledge and our discourse. And so we're doing the CLE, we're starting this section, we're going to have quarterly meetings and lunches, and I hope everyone will attend.
All right. Well, we are approaching the end of our time. Thank you so much,
Thank
Rachel.
you.
She did. As I said, you can engage somebody that actually knows what they're talking about if you don't know what you're talking about. And of course, it's a lot more fun to learn from a colleague about all this type of technical stuff than it is to just try to read through endless numbers of court's orders and sanctioning orders and this, that, and the other to see how everybody else did it wrong, and then you try to figure out how to do it right. But for our clients' purposes, if you do this right up front, the hope is that if the case does go through to a mature state, that you can be much more efficient in getting at your documents. You know, you remember, it doesn't do you your client a whole lot of good if you think, oh gosh, I remember I saw a document in one of those 75 boxes. I think I'll go find it. And of course, 2 weeks later, you might find the document that doesn't say exactly what you thought it said. But if you have everything set up correctly for electronic scanning and searching, you might be able to find it immediately and to draw that decision, whether to use it or not, whether it's good for your case or not. So what we do is we take this joint preliminary planning report, and it has both the plaintiff side and the defense side in it, and you would submit it to the court. And under the court then has a limited period of time, I believe it's 14 days under Rule 16B, to issue a scheduling order that results in the court's conclusions as to which side should win as to any disputed issue, or if the court wants to take issue with both of the proposals of both of the parties, the court can do that as well. And that becomes, I believe I have a sample over here, that becomes basically the Bible for the court, for your litigation. Here's one where the word proposed was marked out by the court, and the court just signed it. But you know, you've got all these deadlines relating to all these different activities in the litigation that result from the Joint Preliminary Planning Conference. And hopefully you will get the number of depositions you think you need and such as that, so that you can then, without having to worry about constantly going to the court, go ahead and pursue your discovery plan and get ready to win. So thank you for your attention. Come back next month for Quillian's Kernels, and have a great day.